Good day class. We will discussing today about risk management, legal and IP issues. What is risk management? It is the process of identifying, assessing, and controlling threats to an organization's capital and earnings. These threats, or risks, could stem from a wide variety of sources, including financial uncertainty, legal liabilities, strategic management errors, accidents, and natural disasters. IT security threats and data-related risks, and the risk management strategies to alleviate them, have become a top priority for digitized companies. As a result, a risk management plan increasingly includes companies' processes for identifying and controlling threats to its digital assets, including proprietary corporate data, a customer's personally identifiable information, PII, and intellectual property. Risk management allows organizations to attempt to prepare for the unexpected by minimizing risks and extra costs before they happen. It is the identification, evaluation, and prioritization of risks followed by coordinated and economical application of resources to minimize, monitor, and control the probability or impact of unfortunate events or to maximize the realization of opportunities. Risk management strategies and processes. All risk management plans follow the same steps that combine to make up the overall risk management process. Establish context. Understand the circumstances in which the rest of the process will take place. The criteria that will be used to evaluate risk should also be established and the structure of the analysis should be defined. Risk identification. The company identifies and defines potential risks that may negatively influence a specific company process or project. Risk analysis. Once specific types of risk are identified, the company then determines the odds of them occurring, as well as their consequences. The goal of risk analysis is to further understand each specific instance of risk, and how it could influence the company's projects and objectives. Risk assessment and evaluation. The risk is then further evaluated after determining the risk's overall likelihood of occurrence combined with its overall consequence. The company can then make decisions on whether the risk is acceptable and whether the company is willing to take it on based on its risk appetite. Risk mitigation. During this step, companies assess their highest ranked risks and develop a plan to alleviate them using specific risk controls. These plans include risk mitigation processes, risk prevention tactics and contingency plans in the event the risk comes to fruition. Risk monitoring. Part of the mitigation plan includes following up on both the risks and the overall plan to continuously monitor and track new and existing risks. The overall risk management process should also be reviewed and updated accordingly. Communicate and consult. Internal and external shareholders should be included in communication and consultation at each appropriate step of the risk management process and in regards to the process as a whole. Steps to implement risk management. 1. Risk identification. It is a good idea to chart your risks in a way that allows you to identify the more common and serious risks so that you know the areas to which you need to commit resources. 2. Quantify and prioritize. Risk mapping is one way to do this. Essentially, you chart all of the identified risks on the map. The map will make you aware of those risks on which you need to focus. Work with your broker to make sure that you are covered for all of the appropriate risks and look for ways to prevent and mitigate these risks. The image on the right is a sample of a common risk map. However, risk maps are often altered to reflect organizational needs. 3. Be risk sensitive, not risk adverse. Being risk sensitive is not the same as being paranoid. Realize that there are risks associated with everything. Take a deliberate and methodical approach to dealing with risk, while at the same time being realistic. 4. Identify risk in business decisions. Identifying risks in business decisions is much the same as with the process of identifying any risk. The key is to be thorough and use all the sources available. These risks can be prioritized and mapped in the same way as all other risks. Risk management approaches. After the company's specific risks are identified and the risk management process has been implemented, there are several different strategies companies can take in regard to different types of risk. Risk avoidance. While the complete elimination of all risk is rarely possible, a risk avoidance strategy is designed to deflect as many threats as possible in order to avoid the costly and disruptive consequences of a damaging event. Risk reduction. Companies are sometimes able to reduce the amount of damage certain risks can have on company processes. This is achieved by adjusting certain aspects of an overall project plan or company process, or by reducing its scope. Risk sharing. Sometimes, the consequences of a risk are shared, or distributed among several of the project's participants or business departments. The risk could also be shared with a third party, such as a vendor or business partner. Risk retaining. Sometimes, companies decide a risk is worth it from a business standpoint, and decide to keep the risk and deal with any potential fallout. Companies will often retain a certain level of risk if a project's anticipated profit is greater than the costs of its potential risk. What is intellectual property risk management? It is the process of identifying, analyzing, and responding to risk factors related to IP throughout the life of an IP right. Proper risk management implies control of possible future events and is proactive rather than reactive. Proper IP risk management will reduce not only the likelihood of an adverse event occurring, but also the magnitude of its impact on the business. If risk management is set up as a continuous, disciplined process of problem identification and resolution, then the system will easily supplement other systems. This includes organization, planning, and budgeting, and cost control. Surprises will be diminished because emphasis will now be on proactive rather than reactive management. IP risk, what are they? By its very nature, there are both rewards and risks associated with intellectual property, IP. Risk is the chance of something going wrong and the danger that damage or loss will occur with detrimental or harmful effects for the organization or company. Risk management is the process of analyzing exposure to risk and determining how best to then handle such exposure. Of course, not all IP risks are the same and they may be broken down into a variety of different categories. One such category is origin, namely identifying from where the IP-related risk comes. Where do IP-related risks originate? Companies and organizations face IP-related risks from a multitude of sources, namely, from within the organization itself. A significant percentage of the IP-related risks that an organization faces originates within the organization itself due to the activities of its own people. Sometimes it is due to a lack of awareness and education of IP by employees, other times it is a deliberate act. Mercedes-Benz announced just recently that they are taking legal action against an engineer who allegedly took confidential information as he prepared to join Formula One rival Ferrari. The engineer, who works for engine manufacturers Mercedes-AMG high-performance powertrains, is alleged to have searched and saved race data. He was set to leave Mercedes at the end of 2015. In this example highlight potential employee theft, but other times it may just be related to poor decision-making by employees, signing non-disclosure agreement, NDA, without fully understanding the content of such agreements, divulging confidential information at a conference without thinking, using the IP of others without permission. Sadly, many IP-related risks facing organizations are in fact due to the behavior of their own people. From entities in the ecosystem of the organization. Traditionally, internal innovation was the paradigm under which most firms operated, with most innovative companies keeping their discoveries highly secret and no attempt made to assimilate information from outside their own research and development labs. However, in recent years the world has seen major advances in technology and society which have facilitated the diffusion of information, and companies now work with people inside and outside of the organization. Collaborative innovation can take many forms, from working with universities, cooperating closely with key suppliers and vendors, collaborating with application developers, content providers, technology house and design houses, plus working with various communities including open communities, innovation networks, as well as customers and end users. It can also involve working with start-ups and venture capital funded entities, as some of the smallest companies can achieve great things with limited funding. However, many IP risks originate from these very same entities within the ecosystem of a company, namely its suppliers, partners, distributors, customers, and even end users. One technology company based in the UK is currently involved in a number of collaborative innovation projects with a variety of different partners. Each project involves different parts of their IP portfolio, patents, data, software, etc., being utilized. Each project has different IP terms and conditions, definition, ownership, usage, scope, etc., associated with it. They have recognized that these collaborative innovation projects are bringing both IP-related value as well as some IP risks to the company, and they are working diligently to maximize the value and minimize the risks. Some entities within the ecosystem of a company just may not treat the company's IP or the IP of third parties with the proper attention and respect it deserves, resulting in IP-related risks to the company. From competitors. IP-related risks posed by competitors tend to get most press attention. Given the very nature of IP and the legal rights associated with it, IP assets belonging to competitors who are designing, developing, manufacturing, distributing and/or selling similar products or services, pose a potential IP risk to any company. This is perhaps best illustrated by looking at the smartphone sector. Smartphones and mobile electronic devices have taken the world by storm. The ubiquity of smartphones has given rise to an incredibly large number of patents being issued to protect all of the technologies vital to these devices. The smartphone wars or smartphone patents licensing and litigation battles are an ongoing business battle by smartphone manufacturers among others. The conflict may be seen as part of the wider patent wars between multinational technology and software corporations. To secure and increase their market share, companies granted a patent can sue to prevent competitors from using the methods the patent covers. Since 2010, the number of lawsuits, countersuits, and trade complaints based on patents and designs in the market for smartphones and devices based on smartphone operating systems such as Android and iOS, has increased significantly. From independent third parties. IP-related risks may originate from entities like IP holding companies, patent assertion entities, and non-practicing entities, NPEs, plus others. Recent U.S. patent statistics show that patent litigation, driven by such type entities, could reach an all-time high in 2015. Although primarily focused on patents and centered in the U.S., IP-related risks coming from independent third parties is not limited to that particular form of IP or to that particular jurisdiction. In the pharma industry sector, we have seen the rise of IP risks from hedge fund managers. One well-known hedge fund manager is taking a novel approach to making money, namely filing and publicizing patent challenges against pharmaceutical companies while also betting against their shares. That strategy utilizes an administrative process known as inter partes review that allows petitions to strike down patents to be heard by a patent office panel. The process was created by the U.S. Congress in 2011 to help companies fight so-called patent trolls, non-operating companies that extract cash settlements from companies they accuse of patent infringement. The Patent Office panel is a less expensive and faster option than trials in U.S. federal courts. From government entities. IP-related risks may come from the activities of government departments, industry regulators, interoperability standard-setting bodies, and of course intellectual property offices themselves. At the beginning of 2015, the Board of Directors of the Institute of Electrical and Electronics Engineers, IEEE, voted to approve a set of amendments to the organization's patent policy. The changes largely relate to the commitment of IEEE members to license patents to users of IEEE standards on terms that are fair, reasonable, and non-discriminatory, FRAND. These FRAND commitments have been the subject of much recent litigation between many of the members of IEEE. Such an IP policy changes brings major benefits to some, but not to others. There are a number of interesting changes or debates about possible changes taking place in the world of IP at the present time. It would be impossible to list all of them here, but it is worthwhile to highlight a few. The US has already pushed ahead with some patent reform, including already switching to the first-to-file system. There are numerous pending bills relating to various aspects of US patent law and procedure, with the Innovation Act, the Strong Patents Act, and the TROL Act being three of the major legislative proposals. Trade secrets can be an important part of an organization's portfolio of IP assets. It is interesting to see the EU working to harmonize trade secrets laws across Europe. The US is trying to strengthen trade secrets laws with the Defend Trade Secrets Act. China's State Administration for Industry and Commerce, SAIC, has announced the opening of a discussion regarding a revision to the 1993 Anti-Unfair Competition Law, AUCL, which includes trade secret law. Some companies will clearly benefit from these reforms, but others may find their IP risk profile changes in an adverse manner. From illegal entities. Here I refer to the activities of illegal entities like hackers and counterfeiters, posing major IP risks to many companies. Hackers are generally external individuals, criminal gangs, or even government-sponsored entities whose sole objective is to gain illegal access to the company's computer infrastructure, with the intention of committing a crime such as the theft of confidential information or trade secrets. Companies that become victims of online espionage are often not aware of any loss until it is far too late. Cyber experts estimate that every company utilizing a computer network is actually being attacked by hackers, who are continuously probing for weaknesses. Counterfeit goods can include fake designer clothes, bags, watches, accessories and perfumes, as well as pirate DVDs, CDs, smartphones, and computer games. They can also include medicines and components of automobiles and aircraft. The size of the problem posed by counterfeiters is staggering. According to FBI, Interpol, World Customs Organization and International Chamber of Commerce estimates, roughly 7 to 8% of world trade every year is in counterfeit goods. That is the equivalent of as much as $512 billion in global lost sales. IP theft poses a risk to all industry sectors. Those most commonly affected by IP theft are manufacturing, consumer goods, technology, software, and biotechnology, including pharmaceuticals. Having personally attended some events organized by customs officials and trading standards officers here in the UK, I am absolutely shocked by some of the counterfeit goods which they have seized. From the organization's own network of IP service and solution providers. Involving an external IP firm or IP service provider into a company's IP operations basically means buying certain work results from third parties. Subcontract work is normally based on the company's specifications and requirements, but the company, and the external IP firm or IP service provider may also compile specifications together. This is a better approach as it enables the external entity to contribute based on their skills, competencies, and knowledge. There are many reasons to subcontract work to an external IP firm or IP service provider. Outsourcing may increase the flexibility of the company's in-house IP in terms of resourcing, leading to faster response times and wider overall opportunities when the competence and capacity pool is expanded. The company may wish to focus its limited in-house IP resources on what it considers to be core activities, critical cases, or key competence areas. Some or all of the tasks of a typical in-house IP function can be subcontracted to external IP firms or IP service providers. The management of external IP firms or IP service providers is, in many ways, very similar to the management of in-house IP resource. It is all about fact-based management and values-based leadership. Subcontracting to an external entity is not always easy. And it can bring tremendous value, but it can also bring risks. What is intellectual property? Businesses in today's economy have to be on the lookout for several aggressive threats to IP, including copyright pirates, patent flouters, brand impersonators, trade secret thieves. Intellectual property is legally protected and includes anything that is created and original. Creators, artists, inventors, and others are rewarded for their creativity when IP laws work to ensure that their works are protected from those who would steal them for profit or personal gain. Economies and cultures flourish when their people create and innovate. If a government wants to encourage a healthy economy, it is in their best interest to offer IP protection and, therefore, give creators incentive to keep creating. Depending on what you create or invent, your work might automatically be protected once it's created. Some forms of IP need to be registered with an agency in order to have protection. Most countries throughout the world have laws in place to protect IP, but not everyone enforces those laws. Counterfeiting can become a big issue in countries without strictly enforced IP laws. Types of IP protection. Intellectual property can be protected in several ways, but the most basic forms of protection are copyrights, protect artistic works like written works, paintings and drawings, sculpture, music, movies, and TV, and even software. Patents, protect inventions that are unique and show progress in technology. Trademarks, protect symbols or words that are used to denote specific brands. Why protect IP? Physical property is well protected, but it only became necessary to protect intellectual property in more recent years. As artists and inventors create products or processes, everything is made so readily available to people across the world. IP is not always in the form of a tangible object, so it can be harder to protect from theft than something like a house or car. If a musician creates a song, it can become accessible to people everywhere fairly easily and quickly. Because the song is intangible, an individual in China can be listening to it at the same time as someone else in Canada. With such ease of accessibility, IP is also very easy to copy. A song that took a long time to write and record can be downloaded and redistributed in seconds. IP law now works to protect the creator's right to profit from their own work. It is illegal for a work to be copied and distributed without the consent of its creator. IP protection usually expires after a certain period, depending on the type of work. Once the creator of a work has been given the chance to profit from their work for a time, it can be accessed by the rest of society free of charge. If someone invents a new form of telecommunication, they are given ample time to market their invention and profit from their work, but after the set period, other companies are allowed to make their invention without owing royalties to the inventor. Intellectual property risks. When the risks involved in protecting a piece of intellectual property are analyzed, this is called IP risk management. There are two main perspectives to consider in this type of risk management, the first party and third party. The first party is the creator and owner of the IP. This company or individual will want to assess the cost of protecting their IP. Risks to the first party include legal costs if IP must be defended in court. Costs if the IP loses value or is no longer considered an asset. Decreased revenue for a protected product or service if the IP is found to be invalid in some way. The third party, individual, or company considering IP rights infringement, must consider cost of a lawsuit and resulting consequences. Potential for poor reputation and subsequent effects. Patents. It is an exclusive right granted for a product, process, or an improvement of a product or process which is new, inventive and useful. Patent is a grant issued by a government giving an inventor the exclusive right to exclude others from making, using, importing, and offering for sale the product of his invention. An invention is any technical solution of a problem in any field of human activity, which is new, involves inventive step, and is industrially applicable. Business method patents. The growth of Internet use and software development has given rise to business method patents. Firms use these patents to assault competitors and subsequently provide income from royalties or licensing fees. Concerns have evolved regarding these patents. E.g., Amazon.com owns a business method patent for the single-clicking feature used by a buyer on its website to order products. Pricelines.com claims that it holds a patent related to its service where a buyer can submit a price bid for a particular service. Startup without a patent. Not all startups will have a product or concept that is patentable. In this case, the entrepreneurs should understand the competitive environment to ascertain any advantages that may exist or to identify a unique positioning strategy. Maintaining the differential advantage may be a challenge but represents an important means of achieving long-term success. Trademarks. Trademark or service mark is a distinctive and visible sign, symbol, emblem, or device used by the enterprise to differentiate its good or products. Trademark or services, service mark, and shall include a stamped or marked container of goods. The use of the mark-generated goodwill that gives value to the IP. A distinguishing word, name, or symbol used to identify a product. Trademarks, unlike patents, can be renewed forever as long as they are being used in business. The trademark is given an initial 10-year registration with 10-year renewable terms. In the 5th to 6th year, the registrant is required to file an affidavit with the Patent and Trademark Office, PTO, indicating that the mark is currently in commercial use, otherwise the registration will be cancelled. There are 4 categories of trademarks. Coined marks denote no relation between the mark and the goods or services and afford the possibility of expansion to a wide range of products. E.g., Mercedes, Kodak. 2. Arbitrary mark is one that has another meaning in our language and is applied to a product or service. E.g., Apple. 3. Suggestive mark is used to suggest certain features, qualities, ingredients, or characteristics of a product or service. E.g., clean and clear, fair and lovely, skin. 4. Descriptive mark, with a dictionary meaning which is used in connection with products or services directly related to that meaning. E.g., rubberoid as applied to roofing materials that contain rubber. Registering the trademark. Filing of the trademark registration must meet 4 requirements. Completion of the written form. A drawing of the mark. 5 specimens showing actual use of the mark. The fee. Initial determination of suitability takes 3 months. Any objections by the entrepreneur must be raised within 6 months, or application is considered abandoned. Once accepted, the trademark is published in the Trade Official Gazette to allow any party 30 days to oppose or request an extension to oppose. If no opposition is filed, the registration is issued and the entire procedure usually takes 13 months. Copyrights. Copyright protects original expression in the forms of literary, scholarly, scientific, and artistic creations. Copyright protection may also be extended to software programs, compilation of databases, and derivative works. Theses may include dramatizations, translation, adaptation, abridgment arrangements, and other alteration of literary or artistic works. Right given to prevent others from printing, copying, or publishing any original works of authorship, such as books, scripts, articles, poems, songs, sculptures, data and music. The protection in a copyright doesn't protect the idea itself, it allows someone else to use the idea or concept in a different manner. The copyright law has become especially relevant because of the tremendous growth of the use of Internet, especially to download music, literary work, picture arts etc. Although software copyright law was added in 1980, issues surrounding access to material on the Internet have led to major legal battles for the entertainment industry. Licensing. Contractual agreement giving rights to others to use intellectual property in return for fee. Licensing is an arrangement between two parties, where one party has proprietary rights over some information, process, or technology protected by a patent, trademark, or copyright. This arrangement requires the license to pay some specified sum to the holder of the proprietary rights, licensor, in return for permission to copy the patent, trademark, or copyright. Types of licensing. 1. Patent license agreements specify how the license would have access to the patent. The license may either just market a product or manufacture and sell also, e.g. telecommunication companies, food franchises etc. 2. Trademark license agreements involves a franchising agreement. The entrepreneur operates a business using the trademark and agrees to pay a fixed sum for use of the trademark, pay amount on sales volume and buy supplies from the franchisor e.g. Shell, Pepsi, Coca-Cola bottlers etc. 3. Copyright license agreements involve rights to use or copy books, software, music, photographs, plays, etc. E.g. Indian Idol, even celebrities can license the right to use their image in a product etc. Before entering into a licensing agreement, the entrepreneur should ask the following questions. Will customers recognize licensed property? How well does the licensed property complement my products or services? How much experience do I have with the licensed property? What is the long-term outlook for the licensed property? What kind of protection does the licensing agreement provide? What commitment do I have in terms of payment of royalties, sales quotas, and so on? Are renewal options possible and under what terms? Types of insurance. 1. Property. In property insurance, possible coverage includes fire insurance to cover losses to goods and premises resulting from fire and lightning. Can extend coverage to include risks associated with explosion, riot, vehicle damage, windstorm, floods. Robbery to cover small losses for stolen property. Business interruption will pay net profit and expenses when a business is shut down because of fire or other insured cause. 2. Casualty, physical injury or property damage, fuel stations/superstores/shops. 3. Life, protects the business continuity, especially a partnership. Workers' compensation, provides benefits to employees in case of on-job injury, chemical/manufacturing industry. 4. Bonding, it protects company in case of employee theft of funds or protects a contractor if subcontractor fails to complete a job within an agreed upon time frame. Contracts. A legally binding agreement between two parties. Entrepreneurs commonly sign contracts with vendors, landlords, and clients. It is very important for the entrepreneur to understand the fundamentals of issues related to contracts while also recognizing the need for a lawyer in many of these negotiations. In case of not availing a lawyer, entrepreneur must take care of following essential items. All involved parties shall be named along with their roles, buyer and seller, licensee and licensor, etc. Detailed transaction, exact location, date, time and place of delivery, etc. Exact value of transaction. Involved persons' signatures must be obtained in the deal. The Intellectual Property Code of the Philippines. The Intellectual Property Code of the Philippines encompasses copyright and related rights, enforcement of IP and related laws, geographical indications, industrial designs, industrial property, IP regulatory body, layout designs of integrated. Republic Act No. 8293 or Intellectual Property Code of the Philippines. The state recognizes that an effective intellectual and industrial property system is vital to the development of domestic and creative activity, facilitates transfer of technology, attracts foreign investments, and ensures market access for our products. It shall protect and secure the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creations, particularly when beneficial to the people, for such periods as provided in this Act. The state recognizes that an effective intellectual and industrial property system is vital to the development of domestic and creative activity, facilitates transfer of technology, attracts foreign investments, and ensures market access for our products. It shall protect and secure the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creations, particularly when beneficial to the people, for such periods as provided in this Act. The use of intellectual property bears a social function. To this end, the state shall promote the diffusion of knowledge and information for the promotion of national development and progress and the common good. It is also the policy of the state to streamline administrative procedures of registering patents, trademarks and copyright, to liberalize the registration on the transfer of technology, and to enhance the enforcement of intellectual property rights in the Philippines. Products and services. Grant and registration of intellectual property rights. Grant of letters patent for invention. Registration of utility models. Registration of industrial designs. Registration of integrated circuits. Registration of trademarks. Legal remedies. Enterprise development. Patent search for the public. Processing and organizing patent documents for classification and developing of search retrieval tools, developing of training modules for patent searches on Philippine patents, providing specialized trainings on search retrieval tools. Technology transfer agreement registration. Evaluating compliance of technology transfer agreements to provisions of the IP code and developing training modules for technology transfer. Mediation. Settling disputes on issues involving technology transfer payments and authors' rights. External training. Organizing training for the public to increase awareness, knowledge, and utilization of intellectual property rights. Advisory services. Providing advisory in patenting, trademark registration, copyright, technical and search. Copyright industries development. Accreditation system. Establishing and administering an accreditation mechanism for collection societies. Advisory services. Assisting in the strengthening of collection societies. Information, training, and educational support. Providing information and education about IP rights for copyright industries. Patent. An invention patent is a government-issued grant, bestowing an exclusive right to an inventor over a product or process that provides any technical solution to a problem in any field of human activity which is new, inventive, and industrially applicable. Patent benefits. A patent is an exclusive right that allows the inventor to exclude others from making, using, or selling the product of his invention during the life of the patent. Patent owners may also give permission to, or license, other parties to use their inventions on mutually agreed terms. Owners may also sell their invention rights to someone else, who then becomes the new owner of the patent. Patent term of protection. The term of a patent shall be 20 years from the filing date of the application. The patent must be maintained yearly, starting from the 5th year. Exclusions of patent. Based on Intellectual Property Code of the Philippines based Sector 22, RA 8293. Discoveries, scientific theories, and mathematical methods. Mental acts, games, business models, computer programs. Surgery, therapy, or diagnostic methods on the human or animal body. Plant varieties or animal breeds or essentially biological process for the production of plants or animals. Aesthetic creations, and anything which is contrary to public order or morality. Utility model. It is any technical solution to a problem in any field of human activity which is new and industrially applicable. It may or may not have an inventive step. Utility model. A utility model, allows the right holder to prevent others from commercially using the registered without his authorization, provided that the is new based on the registrability report. Compared with invention patents, it is relatively inexpensive, faster to obtain, and with less stringent patentability requirements. Utility model term of protection. A utility model is entitled to 7 years of protection from the date of filing, with no possibility of renewal. Trademark. A trademark is a word, a group of words, sign, symbol, logo, or a combination thereof that identifies and differentiates the source of the goods or services of one entity from those of others. Trademark benefits. A trademark protects a business brand identity in the marketplace. Registration of it gives the owner the exclusive rights to prevent others from using or exploiting the mark in any way. Aside from being a source identifier, differentiator, quality indicator, and an advertising device, a protective mark may also bring another stream of income to the owner through licensing or franchising. Trademark term of protection. A trademark can be protected in perpetuity if regularly monitored and properly maintained. The period of protection is 10 years from the date of issuance and is renewable for a period of 10 years at a time. Copyright. Copyright is the legal protection extended to the owner of the rights in an original work. Original work refers to every production in the literary, scientific, and artistic domain. Among the literary and artistic works enumerated in the IP Code includes books and other writings, musical works, films, paintings, and other works, and computer programs. Copyright laws grant authors, artists, and other creators automatic protection for their literary and artistic creations, from the moment they create it. Recordation or deposit of your works isn't necessary, but authors and artists may opt to execute an affidavit of ownership with the National Library or the Intellectual Property Office of the Philippines IPAFL for the issuance of recordation and deposit. Copyright benefits. The creators of works protected by copyright hold the exclusive right to use or authorize others to use the work on agreed terms. The right holder, of a work can authorize or prohibit its reproduction in all forms, including print form and sound recording, public performance and communication to the public, broadcasting, translation into other languages, and adaptation, such as from a novel to a screenplay for a film. Copyright term of protection. The term of protection for copyright in literary and artistic works, and in derivative works is generally the lifetime of the author plus 50 years. Bringing it all together. Example number 1. Decades ago, Coca-Cola decided to keep its soft drink formula a secret. The formula is only known to a few people within the company. Kept in the vault of a bank in Atlanta. Those who know the secret formula have signed non-disclosure agreements. It is rumored that they are not allowed to travel together. If it had patented its formula, the whole world would be making Coca-Cola. The said trademark of said company consists of the word or words Coca-Cola. These words have been generally written as a compound word, and in the particular form represented in the accompanying facsimile, that is to say, with the lower portion of the C beginning the word Coca extended under the entire word, in the form of a dash, and the top of the C beginning the word Cola extended over the letters following in the form of a dash. Upon the dash of the first C said corporation generally has the word trademark. While said corporation prefers to form the initial C's as just described, and also to form the word as a compound word, yet the word may be altogether as one word or separately as two words, and the dash is omitted, without materially altering the character of the said trademark, the essential feature of which is the word Coca-Cola. The Coca-Cola Corp owns the trademark to the name Coca-Cola, as well as the trademark on the bottle shape, and the graphic representation of their name. These are all things that help distinguish them from other cola brands and define their individual product. Coca-Cola also owns the patent on their formula. This means that no other corporation is allowed to make their cola in quite the same way Coca-Cola makes theirs. Coca-Cola also owns the copyright on their ads and jingles, and the creative copy on their bottles. Unless your use meets a fair use standard, you are not allowed to use their copy without receiving their permission. Bringing it all together. Example number 2, reverse engineering would have been easy. Patent for stud and tube coupling system, the way bricks hold together. But, today the patents have long expired and the company tries hard to keep out competitors by using designs, trademarks and copyright. 1934 trademark, leg God, play well. 1958 patent, stud and tube coupling system, the way bricks hold together. 1974 industrial designs, Lego figures, castles, pirate ships, Wild West ranches, cavalry forts, space stations, people. Copyright, artistic work, manuals. Lego has won a trademark battle after a court ruled that its minifigures should continue to be classed as protected shapes, thereby maintaining their position in Toytown. The European Court of Justice, ECJ, rejected on Tuesday an attempt by Best Lock, a Lancashire-based toymaker, to appeal against the trademark protection of Lego's figures. The Danish company registered its figures as a three-dimensional trademark in 2000 after protection under a technical patent registered in the 1970s came to an end. Best Lock, which has sold figures similar to the Lego toys around the world since 1998, first attempted to get the trademark revoked in 2012. Best Lock argued that the shape of Lego's tiny men and women is determined by the possibility of joining them to other interlocking building blocks for play purposes. If the court had agreed that the figures were mere building blocks, Lego's trademark would have been invalid. In 2010, after years of legal action, Lego was prevented from putting a trademark on its 8-studded building brick as the ECJ ruled that to do so would block other manufacturers from producing a basic technical building shape. Today the patents have long expired and the company tries hard to keep out competitors by using designs and copyright. Bringing it all together. Example number 3. Patent for the fountain pen that could store ink. Utility model for the grip and pipette for injection of ink. Industrial design, Smart design with the grip in the shape of an arrow. Trademark, provided on the product and the packaging to distinguish it from other pens. How can IP add value to your business? 1. Increasing market value of the firm. IP may generate an income for your small and mid-size enterprise or SME. Exclusive rights to use and exploit, for limited time, plus prevent others from commercially using your creations. Licensing, sale, patents, trademarks, industrial designs, know-how, copyright. Cross-licensing, using IP as a negotiating tool to obtain licenses from other companies. IP rights can enhance the value of your SME in the eyes of investors and financing institutions. IP rights are one of the 5 main criteria used by European venture capitalists in their decisions to fund SMEs. In the event of a sale, merger, or acquisition, IP assets can provide an extremely valuable bargaining tool. IP assets are separately identifiable business assets and have a separate value. 2. Marketing. Marketing is everything you do to promote your business, so that customers buy your products or services and begin to patronize your business on a regular basis. Differentiating your products/services and making them easily recognizable. Industrial designs and trademarks are identifiers. Customers distinguish, at a glance, between your products or services and those of your competitors. They establish a link between your products or services and your SME. Promoting your products or services and creating a loyal clientele. Trademarks, geographical indications, collective marks, certification marks. Customers associate them with certain desired qualities. Creating a distinct image for your business in the minds of your customers and in positioning your business in the market. Trademarks, trade names, industrial designs, patents. Marketing your products or services in foreign countries. Marketing your products in the new economy. Use of domain names and trademarks in e-commerce. 3. Exporting goods and services. IP rights are territorial. SMEs that intend to export their products should consider legal protection of their IP in their export markets in order to have exclusivity. Whether you commercialize yourself or license. In time. 4. Raising finances. 2 ways of raising funds. Debt, loan which the borrower must repay. Debt finance is generally secured by a charge over the business assets. In principle, these assets can be any claims that have reasonably predictable cash flows, or even future receivables that are exclusive. Venture, which gives the investor a share of the actual business of the investee and is not automatically repaid by the investee business, but rather relies on the investor ultimately realizing the equity held in the business. For the venture capitalist, return depends upon future profits. IP ownership is important to convince investors of the market opportunities open to the enterprise for the commercialization of the products or services in question. 5. Acquiring new technology and finding suppliers. SMEs seeking access to innovative technology developed by other companies should consult patent databases to identify the necessary technology. They may have to negotiate licensing agreements with the patent holder in order to obtain the right to use the technology. Information in patent documents may also assist entrepreneurs in their search for alternative suppliers of identical or similar technologies. 6. Commercializing innovative products. An invention on its own has little value for an SME. How do you turn inventions into profit-making assets of your SME? Trade secret versus patent. The acquisition of a patent gives the SME exclusivity over the commercialization of an innovative product or the innovation process of fabrication. Either, commercialize the invention yourself, or, allowing its commercialization by others. If you choose not to exploit the patent yourself, you may sell or license the rights to other firms that have the capacity to commercialize the patented inventions. A licensing agreement is a partnership between an IP rights owner, licensor, and another who is authorized to use such rights, licensee, in exchange for an agreed payment, fee or royalty. Thank you for listening in our discussion. This is the end of our topic about risk management, legal and IP issues.